Nelson.
Please the court. Macy Nelson on behalf of petitioners Ben Ray and Brendan Corin. This case, of course, is a standing case in the context of a land use dispute. And on behalf of my clients, we are asking this court to rule that for purposes of standing, an immediate neighbor in an urban community is not a member of the general public. All of us are familiar with the Benarski case, which has been part of our jurisprudence since the 60s, and each of us can, I'm sure, quote that case from memory, that to have standing in a land use dispute, a citizen must be able to prove special harm that's different in kind from the general public. And there have been many, many cases discussing Benarski since 1967, and what strikes me as an advocate for citizens in the land use world is that there's no clear explanation in our jurisprudence as to how you define the general public. There's no clear explanation as to how you define the scope of the aggrieved class. There are six.
In your opening remarks, that you think it important that this case arises in an urban area. Is there anything about the regulatory scheme in Baltimore City that would suggest that a different outcome would result than if it arose in any other urban area in one of the counties?
I don't think so. I haven't.
No, it's not something that is peculiar to Baltimore City because of its regulatory scheme. It's just that it's an urban area.
That's correct. That's
more
my
concentrated
view.
development.
That was the point I was trying to convey.
Okay.
Got a little nervous, though, with the question.
It's not a trap for the unwary.
I feel better.
In following up on what you said thereafter, you say there's no clear distinction between the members of the public and those that are what we might call specially aggrieved?
Well, I call it the members of the aggrieved class.
Do you see this case as going to help define that?
Absolutely.
So you do?
Absolutely.
Okay. Then help me here. You know, what is it that you would say that is the special aggrievement or whatever, the specially aggrieved? What is that definitional element here that you would write that would distinguish, you know, that if you were writing the opinion, that would distinguish these two people or the group from any other group in this urban area?
If I were writing the opinion, I would attempt to articulate these thoughts. To answer the question as to whether Messrs. Corin and Ray have standing, we need to have understanding of geographically where is the general public. We need to understand that, because those are the people against whom we compare my client's harm. So we need to define the general public, and we also need to define the scope of the aggrieved class, because we know that there can, from the Alvey case, there can be more than one citizen with standing. There can be more than one member of the aggrieved class. So there could be a case with 20 people or 100 people who have standing, but only one has the resources to go to court, and you can't compare his aggrievement with his neighbor who can't afford to go into court, his immediate neighbor. So you've got to compare it to somebody in the general public. So I would suggest we need to define the general public. We need to define, how do we define the aggrieved class? And I propose...
In here, what is the aggrieved class? That would be the definitional element that would help forever and ever, define it.
If I were writing the opinion?
Yes.
I would say the general public is anything outside the neighborhood.
And what then is the neighborhood?
Remington, I would first say that we know in our land use jurisprudence, in the special exception cases, in the reclassification cases, there's this concept of, this is a term of art, the neighborhood. It's a flexible concept that's case-by-case analysis, but in this case, I think we're going to use that concept, apply it here, and say that the neighborhood here is the Remington and Charles Village communities, which are designated in the Baltimore County Master Plan, And anything outside those neighborhoods, the neighborhood, is the general public.
Well, isn't that usually a question of fact that is determined by the trier of fact, which I guess in this case would be is it Board of Zoning Appeals?
Well, there was we didn't confront standing until we got to the circuit court. But, I'm sorry.
So has anybody, before you got here, defined the neighborhood?
In this case?
Yeah.
No. But,
so, can we really do it, or?
Well, no.
Are you really asking us to send it back down to define neighborhood, have someone define neighborhood?
I'm asking for a reversal, because what the Court of Special Appeals did was, let's just take Mr. Ray, for example, who lives at the corner of 31st and Remington. And in his affidavit, which is in the record at page 59 or 60, he says he says he lives there and that there's going to be a confluence of traffic at the intersection of 31st and Remington where I live. And then he said it's a narrow street, there's going to be too much traffic, and the few people who live right at that intersection, including me, will be harmed by it.
So are you really asserting that this appellate court should define what the neighborhood is, should make a finding as to what the neighborhood is?
If I were writing the opinion, I would first say, first of all, the Court of Special Appeals erred because it compared Mr. Ray's traffic complaints with his next-door neighbor at 31st and
Getting to my question?
Yes, and then an explanation of why the Court of Special Appeals erred. This is more sort of rationale, not holding. An explanation is the Court of Special Appeals confused members of the aggrieved class with the general public. So the way to understand it is to say that the Court of Special Appeals is holding that an immediate neighbor in an urban environment is a member of the general public is flawed. Does that?
So, are you asking us to make a finding as to where the boundaries were of the neighborhood?
Well, I would say that if the court wanted to write a narrow opinion, you don't have to do that. I would say that the court could say that the Court of Special Appeals erred because by finding people next door to Mr. Ray, where members of the general public was an error, the court could write a more expansive opinion should it choose to do so. And I understand the whole ideas of sometimes the opinions are narrow, sometimes they're broader, but the court could do that because there's evidence in this record that we submitted about the master plan and the neighborhood, and so yes, you could do that, but it's not necessary to get a reversal.
Were your clients persons of record in this case before the judicial review action was initiated?
Yes. I don't have that record reference at my fingertips. I can get it, but the answer is yes.
So, because Baltimore City's regulatory scheme for establishing a PUD such as this is a little different, it seems, than any of the counties. Was there an occasion for a quasi-judicial?
Those are words with meanings, you know, and there were public hearings, people spoke.
But they were like legislative hearings. You could come in and testify, but somebody who was opposed didn't have a right of cross-examination.
Yes, Your Honor.
So it was more a quasi-legislative process.
Right, but I don't want to concede that because that creates questions about judicial review. But as a factual matter,
and your clients, they testified in opposition to this, yes?
I believe so.
In writing or in person?
Yes, at least in writing. Getting back to Judge Atkins' question about do we have to define it, I would say that there are signals in this court's jurisprudence about how you look at the aggrieved class. Benarski talks about the Protestant had standing because there was an increase of traffic and change in land use in the area where he lived. That's suggestive that anyone in that area would have standing. The Weir case from 1970 uses that same language, says the Protestant lives a mile away meets the test for standing.
You know, as I read your brief, I was looking for a case that
I'm sorry, I didn't hear the question.
As I read your brief, I was looking for a case that would help me get very clear in my head what persons had standing and what the standard was. And what I deduced was the cases are very individual, that they're quite factual, that there is no clear definition of where you have to live or what your injury has to be in order to acquire standing. And I'm wondering if perhaps that's because that determination is so factual that it has to be made at a lower level than the appellate court.
I disagree. I mean, the rule is clear. The citizen must show agreement that's different in kind from the general public. And there are cases that talk about it, but they never speak with precision, in my opinion. They never say, well, who's in the general public? So I think what this court needs to do, if I can be so bold, I'm asking you, you're asking, I'm responding to your question, is that an immediate neighbor of Mr. Ray's, for example, at the corner of 31st and Remington, is not a member of the general public. We know what the test is. The question is, against whom do you compare?
How you apply it.
Well, to whom do you compare the agreement? And what
That's one way of looking at it, but not perhaps the only way.
Do the neighborhoods, to use the word, of Remington and Charles Village have designated boundaries that are undisputed?
Yes.
And so your position is everybody within Remington and Charles Village are aggrieved?
No. That's
okay.
not my...
Okay.
No.
Then tell me...
All right, first of all, the boundaries are well defined in the Baltimore County Master Plan. Mm-hmm. Those boundaries are relevant because we're arguing to this...
Baltimore County or Baltimore?
Baltimore City. I misspoke.
Okay.
I apologize.
Okay.
Those boundaries are relevant to my argument because I say that anybody outside those boundaries is a member of the general public. So you have to go outside the boundaries to find someone you can compare your harm to.
Okay.
All right. Just because you're inside the boundary doesn't mean you're aggrieved. You've got to show that you have harm. There could be somebody with no harm. And this is where I thought we were clear, and we tried to spell it out in our reply brief. My adversaries thought we were arguing everybody in the neighborhood as a matter of law was aggrieved. We're not saying that. We're saying that you've got to compare their harm to people outside the boundaries.
Okay, so long, all right, then with regard to your client, as compared with, say, someone who resides in Waverly, their harm is going to be more direct, correct?
If they have evidence of harm, which we did, more traffic, change of character, depreciation of property value, yes.
Now, would you talk for a moment about the alleged harm from walking through the neighborhood and being unable to find and utilize the same business establishments that you used to, because those businesses have ceased operating due to the Walmart, et cetera. Is that, which cases discuss whether that harm in itself is sufficient to establish standing?
I believe Benarski and Weir do.
Benarski and Weir?
Yes. They don't talk about big box development, but they talk about a change in the use of land as a basis of standing, a change in the character of the land.
Okay.
Benarski and Weir. Now, if my adversary were at the lectern right now, he would cite the White case, 251 Maryland 63, which there's dicta where the citizen talks about a change in the character. It doesn't say it's an adverse change, but the court said that's not a basis for standing. But I think the three cases that address this point are Benarski, Weir, and you can look at White, and I think that any fair reading of White, it's a per current opinion, it's about that long. There's no evidence of adverse harm. So I think Benarski and Weir address that.
Thank you.
Is there any requirement in the Baltimore City Code that either an applicant for a PUD or the mayor and council, before they grant a PUD or establish a PUD, has to define a neighborhood?
I'm hesitating because there's a reference in the record which we cite in our brief where they do define the neighborhood, and they do it in a way that's broader than the way we do. They talk about more communities than we do. I could go to my brief to find the precise reference. Whether that's a mandatory requirement or not, I'd have to go and look at the PUD statute. But I know that they did define the neighborhood more broadly than we as advocates did.
They did. You mean the city code?
That
was my question.
The short answer is I don't know if the city code requires it. I do know that in the record the neighborhood was defined, perhaps by staff. I'd have to go to the reference to answer your question with precision.
When you come back, you can tell us.
Yes. The other narrow point, Judge Atkins was asking how broadly do we need this, am I asking the court to be, and that's ultimately for your decision. But there's precise evidence of depreciation offered by Mr. Coyne in this case. We relied on Brannon, 305 Maryland 793, which was a condemnation case, but where this court established the rule that a layperson, assuming this person has some evidence about values in his community, his neighborhood, can offer an opinion about before and after. We rely on Brannon. Mr. Coyne offered precise evidence, extracts 63 through 67, that he was familiar with the property value in his neighborhood. He's been there for a number of years. He's been looking to buy a rental property. He's familiar with the housing stock, and he expressed the lay opinion that this proposal would have an adverse effect on his depreciation. As an advocate reading Brannon, I say that is good evidence, black and white. The Court of Special Appeals said, well, no, we reject that evidence because his depreciation is the same as his neighbor's, and therefore it's no different than the general public. I say that what the Court of Special Appeals did was compare his depreciation with other members of the aggrieved class instead of going outside the boundaries of the neighborhood. My adversaries argue, well, Brannon should be construed limited to a condemnation case. I say I disagree. This Court has applied it in Williams. Another adversary says, well, you can't give before and after. I say it says so in black and white. You can do a before and after. So for all of those reasons, we urge this Court to reverse the Court of Special Appeals. You could do it narrowly by saying that Mr. Ray's neighbors at the corner of Remington and 31st are not members of the general public, so they're not a good benchmark for harm. Same for Mr. Coyne's neighbors about depreciation. Or the court could go issue a broader opinion and say that in future cases we need a definition of the general public, and I advocate that you use the boundaries of the neighborhood as the interior boundary of the general public. Our clients are grateful
for your argument. You're defining an aggrieved class, but they don't necessarily have standing.
No, I would say differently. First, I say, what is the general public?
I understand the general public versus the aggrieved class.
The aggrieved class.
All of the members of the aggrieved class have standing.
Yes, but not all residents of the neighborhood are aggrieved. Now, the aggrieved class are those people who can prove aggrievement.
But if they can see it, like
it-
one of your clients,
Yeah, I mean, it's.
and property
it's-
values are going down,
I'm sorry, I didn't hear that.
if they can see it and values are going down because of all these factors, why
Yes.
aren't they aggrieved?
They are. The point I was trying to,
All I'm trying to do is figure out who has standing here.
all right,
I mean, in the sense that the general public does not have standing, but there's an aggrieved class according to what you're saying.
Yes.
And the Court of Special Appeals made a mistake by comparing your clients to other members of the aggrieved class.
Right.
Do the other members of the aggrieved class within this neighborhood have standing?
yes, if they're aggrieved.
So
If they have-
everybody,
everyone who has it,
wait a minute, do people who are members of the aggrieved class, are they aggrieved?
yes.
Okay, that's all I need to know.
So everybody in the Charles Village neighborhood can have standing to file for judicial review?
I would say maybe, but I'm not asking this court to rule that. Any member in the neighborhood who has evidence of aggrievement will have standing, but because you're there doesn't mean you get it with a blank check. You've got to have evidence of aggrievement.
That just means you have to bear your burden
Right.
if you go into court. But the question is that potentially everyone in the neighborhood, as you've defined it, could have standing here.
The answer to that question is yes.
Because they can see the Walmart, for example.
For example, or the property is depreciated or the character is changed, but they'd have to come forward with some evidence. All I know is my clients came forward with that evidence.
Thank you, sir.
Thank you very much.
Hirsch?
Thank you, Your Honors. May it please the Court. Charles Hirsch, on behalf of the developers and contract purchasers of the 25th Street project. It's an important project. We recite why in our brief. It is being held up by this appeal.
Well, Frank, to put that bluntly, what does that have to do with the price of eggs here?
The most critical issue is the timing. And the reason that standing is important, particularly in these types of cases, is that if you don't have standing, you can't stand in the way of a project. Because
True enough. But
and that's the significance, because anybody could come in and block a development project. And that's the standing requirement is the gatekeeper to prevent people from doing that.
right, but how? Well, go ahead, please. With your argument, counsel.
And it is especially significant because we have been at this for almost 3 years. The PUD process itself took about a year, and it's been almost 2 years since the PUD was approved and signed by the mayor.
Well, I guess I'll ask one more question.
Certainly.
That's akin to the first. How does that help us resolve the legal question whether these individuals have standing?
Again, it underscores the importance of upholding the standing requirement, number one. But the reason that I'm mentioning it is because of the next thing that I'm going to say, which is I'm mindful of how busy this court is, but we have been at this for a long time, and my clients have spent a lot of time and a lot of money and have not been able to proceed. And so, however this court rules, we encourage you to do it as quickly as possible, even if it's an order with an opinion to follow. But, you know, we are certainly mindful of the court's schedule. But that's where we're coming from. Now, to address how the court makes the decision, I would like to discuss some of the things that Mr. Nelson brought up. Specifically, I want to talk about the neighborhood, because the neighborhood is a red herring. And the real focus of this court is because this was an affirmance, the Court of Special Appeals affirmed what the circuit court did. The focus of this court was the decision of the circuit court legally correct? And Mr. Nelson doesn't really talk about that in his original brief. The reason being, he has nothing to say. So what does he do? He conjures up this argument, taking bits and pieces from the Court of Special Appeals opinion, and says, well, there's this neighborhood issue.
Well, who, in your opinion, has standing to have judicial review of a PUD determination?
To have standing, you have to either be prima facie aggrieved, which Mr. Nelson has conceded his clients are not, meaning that you are so close that that you don't have to carry a burden of proving that you're specially aggrieved. It's presumed.
And
that's not an issue.
Well, just tell us who's within the prima facie class.
The prima facie class, I think, would be anybody who's directly abutting. You have to be right there. It has to be staring you in the face.
All right. So abutting, and he's out. Now what?
And so that's not an issue. Mr. Nelson has conceded that in his reply.
Could it be more than abutting?
It could be more than
adjacent.
It could be.
How about surrounding properties?
Yes.
Because those phrases pop up.
Exactly. But I think the way the cases have focused, it really is, you're talking, whether you're using the word abutting or adjacent or surrounding, you're talking about really looking right at this property, being right in front of it.
Right.
That's not the case here. So what we're talking about is the protestants having the burden of proving special aggrievement. They have to prove that they're impacted in a way different from the general public. That's the standard that the circuit court used. That's the standard that the Court of Special Appeals used. They both quoted and relied upon the Bernarski case. Everybody agrees that's the standard.
Well, do you think that being close enough so that you daily walk through the neighborhood utilizing the services of various businesses is enough to establish standing?
No, Your Honor. And there is not a single case that has ever held that. The Weir case doesn't say that. Bernarski certainly doesn't say that. Bernarski was a prima facie case.
Okay.
So that has nothing to do with it.
So use of the businesses and walking and enjoying Zippo, nothing.
That is exactly correct. That has never been the basis for this Court's decision in any aggrievement case.
How about traffic?
Likewise, Your Honor, traffic has not been an issue either. We cited the White case, the Dubé case, the Wilkinson case, and all of those cases had testimony that, oh, it's going to increase traffic. This Court has said in all of those cases that's not enough.
So to have judicial review of a PUD determination or approval is much harder than to have judicial review, say, of a special exception or conditional use or I can think of.
That's right, Your Honor. I mean, the standard for being aggrieved in a zoning process, I mean, it's analogous to zoning. That's where it comes under the code. And so it is, if you're not right in front of it, if you're not right there and have presumed aggrievement, you have the burden of proving that you're specially affected.
It's analogous to zoning.
It is a zoning decision, essentially. This is.
I'm just curious why you agreed with Judge Atkins that it's more difficult to establish aggrievement in a PUD case than other kinds of zoning decisions?
No, then that's not what I'm saying. I'm saying there are different considerations, particularly for special exceptions or things like that.
But doesn't the governing standards for establishing a PUD in Baltimore City bootstrap in the standards for Title 14 conditional uses, which are Baltimore City's special exceptions?
It does, Your Honor.
But they use neighborhood.
But
And you don't.
and aggrievement does not. And that's exactly the distinction that I'm trying to make, is that there may be some other issues relating to conditional uses, but that is not the standard for aggrievement. And the aggrievement standard is the same as in other zoning cases. And to be aggrieved, you have to prove special harm.
Well, one of your earlier examples was you rattled off 3 or 4 cases where simply increased traffic in and of itself was not determined to be satisfactory proof of aggrievement. Yes. What if the increase in traffic at an intersection through which one of the residents in the vicinity must travel to go to work would dip below a level of service that is deemed unacceptable in the particular jurisdiction? Would that be enough?
If you had expert testimony that made that argument, I would say it's possible.
So in order to establish the threshold of standing, a citizen has to produce expert testimony, or he or her has to be an expert?
To meet certain burdens, I would say that's correct. And in the Weir case, for example, there was expert testimony, and the court acknowledged that. But
pretty atypical, though, wouldn't you, in your experience?
Well, but there's not a single case where this court has found standing for an issue such as that where there was an expert testimony. And in fact, the Wilkinson v. Atkinson case involved a situation where the complaint was increased traffic will make it more difficult and more dangerous for our kids to go to school. The court said that's not enough. So this court has never used lay testimony to make a traffic argument. And another case was the Marcus v. Montgomery County case, which also addressed traffic. Same thing. It said lay testimony, that's not enough. And even, as I said, in a serious situation where the allegation was that it would impact kids going to school.
Let's try a different tack. Tell us a case where there was found to be aggrievement.
The cases that find aggrievement typically are the cases where you are right next to the property.
So what
Well,
you're
that's
saying is,
that's true.
I'm trying to find a case where there was aggrievement and it's not prima facie.
It's not.
If what I'm increasingly hearing you say is that the only way you're going to get any standing at all is to be prima facie. That's basically what you're saying, isn't
In
it?
a PUD case?
Well,
He doesn't draw the distinction between
Correct.
PUD and other things. So
That's
yeah,
correct.
So his point is, that's it, right?
No.
I wouldn't say that's it, Your Honor, but this court has not found in very many.
What would suffice then?
If you came in with expert testimony, if you said that, to use some examples from this case, if you had expert testimony that there was a diminution in value, if you had expert testimony that there was some serious impact, the kind of cases where you have it are environmental cases where there's debris that is being discharged and it's affecting your property. The Alvey case, which Mr. Nelson mentioned, that was a marina that was discharging, all kinds of refuse. The individuals were 150 feet away. They owned property 150 feet away, and refuse, including human waste, was being discharged, and it was floating right down by their property. That's an example of special aggrievement. And Mr. Nelson is trying to create this notion that the whole neighborhood is impacted, therefore they're all aggrieved. Not one case, not one single case by this Court has ever used a neighborhood to define aggrievement. And in fact, in all of the cases that I've mentioned that denied it,
It has never looked at neighborhood?
correct. It has not once looked at neighborhoods. And let me give you an example of why.
What cases are you talking about? What's your world of cases?
All of the cases that talk about aggrievement in a zoning situation, and I'll list them for you.
A zoning or rezoning, not a special exception or conditional use or variance.
Well, a judicial review of either a PUD case or a zoning case, not one of them has talked about the neighborhood. And examples include Marcus v. Montgomery County, White v. Major Realty, Dubé v. Crane, Wilkinson v. Atkinson.
Where does neighborhood come from? Because I know it's in the case law somewhere.
It is a consideration, and Ms. Gutman is actually going to address that point. It is a consideration in a change of neighborhood. If there's been a change.
Change of mistake cases, Euclidean rezonings.
Correct.
And possibly in special exceptions.
Correct. That is correct.
Are any of the standing cases that you rely on involved a floating zone like a PUD?
None of them are PUD cases.
So there's no opinion of either of our appellate courts in which standing was a decided question that involved a floating zone.
That is correct. That is correct.
And outside Maryland, have there been decisions setting forth standard of review or standing in a PUD-type situation?
Not that I'm aware of, and certainly there's been no distinction made between standing for that type of review and standing for any other type of zoning review. It all comes within the same statutory framework. So it's all governed by.
So you're sticking with Judge Harrell's answer, which is that PUDs are not any more. It is not more difficult to have standing to seek judicial review of a PUD than it is any other type of decision.
It is governed by Article 66B, Section 2.09, and I would say that any review that is governed by that statute has the same standard, and I've not seen any cases from Maryland or otherwise that has made a distinction between if it's a review for PUD or if it's a review for anything else.
Is that because we analogize PUDs to special exceptions in many ways?
I don't believe so, Your Honor. I believe it's because the standard is the standard. You're aggrieved if you're impacted adversely.
But those words, aggrieved and being impacted adversely, they're nice words. But what do they mean?
They mean that you have to prove that you're damaged in a way that other people aren't, that there is something special and unique to your situation.
And those other people, are they the people that live in Timonium?
No, Your Honor. Again, this Court has taken a very restrictive view and has found there are cases, the Dubé case, the homeowner lived 1,500 feet away. The Wilkinson v. Atkinson case, 750 feet away. Marcus versus Montgomery County, a quarter of a mile away.
Well, that's further away than this case.
No, this is 0.4 of a mile. This is almost half a mile away. So there is not a single case.
Special aggrievement in Dubé.
I beg your pardon?
In the Dubé case, What was the special agreement?
There was no agreement.
The case where they were a quarter of a mile away.
The court said that they were not aggrieved.
Oh, okay.
That's what I'm saying. All the cases that I listed, this court said, all of which are closer than Ray and Coyne here, and this court said there's no aggrievement. Because you're not opening the courthouse door to everyone who may have some issue with the development. And it gets back to my initial point. Yes, it's not determinative, but it is something that this court has to be mindful of, the policy behind standing itself, and especially in this context. And I quoted towards the end of my brief from a law review article at pages 30 and 31 of my brief, and basically, and it was talking in the context of a PUD, it said standing is really important, because if you don't limit the number of people who can come in and protest, you're never going to have development.
What you're saying, though, counsel, is that construing standing narrowly is important.
In this context,
that's your perspective, I would say.
Yes, and it's not so much the standing necessarily, but it's the aggrievement. And it is whether or not you have sufficient harm, different from everyone else. There's no allegation here.
Well, when you say that, you don't mean to say that there's only one protestant who could have standing. When you say different from everyone else. You and similarly situated persons, different from everyone else.
Anyone who would be specially affected, anyone who has some type of harm that's different, and I grant you that general public is a vague term, but at the same time, this is not a close call. This is not a case where they're right on the borderline. Boy, they really seem close. They're not close. Judge White in the circuit court said that. Judge Moylan in the Court of Special Appeals said that. This is not a close case. These folks are sufficiently far away, and the harm that they've articulated is so attenuated that this is not the case in which the court, if it wanted to draw a bright line test, would have the facts to do it.
So in this case, who would have had standing other than prima facie? And this is, I may be reiterating a question that Judge Harrell asked, but in this case, who would have had standing?
It's difficult to speak to the hypothetical because they'd have to be harmed in some way. You would have to have, putting aside someone who is right next to the project, you would have to have some special difficulty created by the construction of this project. And
traffic is only enough if you have an expert testimony?
And if it is really different from what everyone else is going to be experiencing. I mean, the fact is that lots of people who live near and far, drive through these streets. So there's no magic bullet to being, on a street near the project. Thank you, Your Honors.
Ms. Gutman.
Bill, you asked my colleague to cite any case where there was a finding of agreement that didn't rely on prima facie agreement. I would like to answer that question. The best case, or a case, is the Weir case, 257 Maryland 600. There were three protestants in that case, Weir, Critcher, and Magersup. The court found that each had standing, each, not just one, each. Weir was, depending on where you look at the opinion, either 150 feet away or 1,100 feet away. Critcher was 1/2 to 3/4 mile away. He had standing. And Mr. Magersup was 1 mile away. He had standing. That's one example. Another example is...
Was that a Euclidean rezoning case or special exception case? I doubt we had floating zones anywhere at that time.
I can answer that in 2 seconds. It's a zoning reclassification case. That's one example. Benarski is another good example. And I must say, my colleague says over and over and over, Bernarski is only a prima facie case. I disagree. I direct the Court's attention to pages 147 and 148. And what the Court says is that
What's the site?
247 Maryland, 137. And the pages to which I refer the Court now are pages 147, 148. And there are two paragraphs. The first paragraph talks about prima facie agreement. They are. And then the Court goes on to say they also meet the test for proving agreement. And what evidence does the Court cite to? Lay testimony about increased traffic. Lay testimony about increased traffic.
And what was the type of zoning action in that case?
This was a special, excuse me one moment, special exception case. So, but there's more in Bernarski. A lay witness described his, quote, belief. That's the word of the opinion. Belief about increased traffic. So Bernarski addresses prima facie agreement and agreement we have to prove, contrary to what my colleagues argue, and it also endorses a belief about increased traffic. That's another example. A third example, Judge Bell, is the sugar loaf case. And then Sugarloaf, this was Judge, I think, Eldridge's opinion, reads the Bailey case, 216 Maryland 536. I'm going to quote from the opinion. Standing according to zoning reclassification, protestants who lived 3/4 of a mile away by road and between 1/3 and 1/2 a mile away as the crow flies. So those are some examples of agreement.
Refresh my recollection. Sugarloaf, wasn't that an environmental permit case?
Yeah, it's not a perfect model.
And in some of our environmental permit, older cases as to standing are now probably moot, considering the new standard that the Patuxent Riverkeeper case, interpreting how the Fed's standing requirement in environmental permit cases is now Maryland.
Depends on the permit, of course.
A new statute.
You're right. It's not a perfect model. I just like the case because it's air pollution and it traveled 2,000 feet. But it's not a perfect model. Judge Bell asked me to respond in my reply about where in the record is a reference to the how the PUD defined the neighborhood. It's extract 48.
How was that doing that on behalf of Judge Atkins?
Well, Judge Atkins, it's extract 48, where the PUD statute talks about how they talk about the neighborhood. They do it in a way that's more broadly than the way I did in my papers. And I don't mean to suggest that they were using the neighborhood in the legal way that I was using it, but when they talked about the affected area, they had a broader area than I described. Extract 48.
Thank you.
There was a question about out-of-state cases, and the only out-of-state cases that we could find that were relevant to our argument were cases that tried to distinguish between the general public and the aggrieved class, and there weren't many, to be frank. We looked hard. We cite these cases at pages 15 and 16 of our opening brief, and for example, there's a Utah case that cites in our papers, but Hirsch, that's the Utah case, emphasized that this does not mean that a particular plaintiff must show damages different from his immediate neighbors. He must only show damages that were more substantial than those suffered by the general public. That's precisely the point my clients make in this case. And finally, Judge McDonald's question about Judge Moreland's opinion, head note 18, rebutting presumptive non-agreement. That thought struck me this morning as I reread the opinion. I do think that he's got it backwards, that my clients have a burden to come forward with evidence, which we did, but I think that this is just another way in which the lower court erred by just making the burden too high for my clients just to enter the courthouse doors to present their technical objections to this PUD. On behalf of Mr. Corn and Mr. Ray, I thank the court for the court's time and attention. They're grateful for all of it. Thank you very much.
Thank you all. Number 18.